Good morning, everybody, and welcome to our webinar today. Today, Kate Chalker from the Sydney team is going to be taking us through how to defend asset protection strategies that we might have in place for clients, or how we just generally deal with disputes. Being based in Sydney, I must admit, seems to be an increase recently of what I call people fighting over money, whether that's people not paying bills, or whether that's commercial disputes, or whether that's the tax office coming after people. But unsurprisingly, there does seem to be a little bit of an increase in that activity. So this is a timely webinar for that. If you haven't joined us for a webinar yet, I'll just go through a couple of things in terms of the webinar platform itself. You should be able to download a copy of the slides by clicking on the Files button. Last couple of times we've done this on first go, it hasn't worked properly in terms of the download, but if that occurs, just let me know and we'll reload them. The other thing as well, you can ask questions during the presentation by entering them into the chat box, and you can either make them public so everyone can view, or private. If you don't want everyone to view it, that will come through to me. I'll be moderating the session today and relaying those questions to Kate. Of course, you can ask questions either during the presentation or at the end. We'll leave some time at the end. If you've got questions at the end, just fire them in, and if appropriate, I'll break into Kate's presentation and ask them at an appropriate time. Today's webinar is recorded, just so that you know. It will be available on our website later on today. So again, with those questions, obviously we won't be putting any personal details if you've included them in the query. So considering that this will be recorded. So I'd like to introduce Kate Chalker, who will be presenting our webinar today. As I mentioned, Kate is based in our Sydney team and does a wide variety of work within the firm. I don't know whether you could say she enjoys the dispute part. However, it's certainly a large part of what she does from day to day. So without further ado, I'll hand over to Kate.
Thank you, Adrian, and good morning, everyone. Thank you again for tuning into our third and final session of our asset protection series. Hopefully, if you were able to tune into the two previous sessions, you would have heard from Helen and Kim in relation to the different types of asset protection strategies that we offer for clients, whether that's individual clients or other entities, including companies and trusts. In my presentation today, I'll be taking that one step further and looking at the practical steps that would need to be taken to actually enforce those strategies or to defend the client's assets in the event that a claim were to arise. So just going through the agenda for this morning, for those of you who weren't able to tune in for the past couple of webinars, I will go through a very brief recap of the different types of strategies that can be implemented for different clients. I will then take you through a mind map of the litigation process, and also go through where the asset protection strategies can interact with that process, when they can be used and how they can be used. With that, there are a few different approaches that can be taken depending on the circumstances surrounding the claim and the client. So I will go through what those different alternatives are and the benefits in going through each of those approaches. I'll then go through the different considerations which need to be weighed up because there is really no one-size-fits-all approach that fits every single type of commercial dispute. So I'll go through the different types of questions that would need to be considered and weighed up for every individual commercial dispute. I'll then go through some of the impacts and complications surrounding bankruptcy or insolvency, because unfortunately that's something that can't be avoided when we are talking about a commercial dispute. And then finally, I will take you through a brief case study based on a client of ours, and that will demonstrate how the asset protection strategies can be used in the event of a claim and ultimately bankruptcy. So like I said, I'll take you through a brief recap of the different strategies that we do offer. The first one, which I've got on this slide, is our secured debt strategy, where we have an individual client. So that individual may be in business, or he may be in a risky profession like doctors, lawyers, accountants, etc. And so where they have built up a fair bit of wealth in their individual name, we would need to look to protect those assets because there is that inherent level of risk. So in that situation, we would look to have the individual make a gift from themselves to a bloodline trust, which they control and of which they are a beneficiary. And that gift would be made by way of bearer promissory note, which is essentially a two-person check. And the amount of that gift we would want to make equal to the net equity in their personally held assets. So for example, if they own a $2 million property and there's $500,000 owing to a bank, we would want to make a gift of $1.5 million there. Once that gift has been made, the trust would then loan that amount back to the individual under a formal loan agreement. And like any other lender, they would want to take security for that loan. And that security would normally take the form of a registered mortgage if we're talking about real property, or if we have personal property such as shares or motor vehicles, that's when we would have a registered security deed on the personal property securities register. And so the ultimate effect of implementing that strategy is that ownership of the assets remains with the individual. However, there is a secured debt owing from the individual to the trust, and security taken over their assets to reduce the potential risk for that client and to reduce the equity that could potentially be attacked by creditors. On this slide, I've set out the secured debt strategy or other strategies that we offer for company asset holders. So on the left-hand side, we've got Trading Co. Proprietary Limited. There may be assets built up within that company, or there may be significant retained earnings which have built up over time. That company may also have some franking credits available to use. In that situation, we would normally create a new class of shares within Trading Co., which we call discretionary dividend shares, or you may know them as dividend access shares. And those shares would be issued to Reserve Co. Proprietary Limited. And for asset protection purposes, we would normally recommend that the shares in Reserve Co. be held by a discretionary trust. And then once the shares have been issued, we would then look to declare a fully franked dividend out of Trading Co. to Reserve Co. If Trading Co. would like to keep the money for cash flow purposes, Reserve Co. could then loan that money back to Trading Co. And similarly to the individuals, it could take a registered security deed over Trading Co.'s assets. So similarly to the last slide, the result of that would be that the retained earnings in the company would be greatly reduced and there would be security over Trading Co.'s assets, which would afford great protection. And then the final strategy, which I've got here, is where we have a risk trust holding assets. For example, you may have a trust which is in business, and yet it may have some assets which could potentially be at risk. So in that situation, again, it's fairly similar. However, for a trust, we would be looking to revalue the trust's assets to market value, make a capital distribution of that amount to a bloodline trust. And then again, that amount could be loaned back to the trust and then security registered over the assets. So as you can see, they're all fairly similar in what we're trying to achieve with those strategies. It just depends on the structure of ownership. However, the ultimate goal is to move the value away from the risk entity to a safe haven entity, such as a bloodline trust. And we look to do that moving the value so as not to trigger any significant tax liabilities for the risk entity. At the end of the day, the ownership does remain with the individual, company or trust, but the net equity available to creditors would be greatly reduced, hopefully to somewhere near zero, because there would be that secured debt owing to the bloodline trust. I should point out that there are potential clawback provisions which would typically apply to transactions such as these, because generally in asset protection work, you are looking to move value away, so there's generally no consideration paid for those gifts or for those transfers. So the undervalued transaction clawback could potentially apply. And I'll come back to that being a potential issue further in the presentation. So normally when we implement asset protection work, we do it when things are generally looking fairly good for the client and there's no major risks present at the moment. And we do that with a view to the future, knowing that there is always a potential for risk and always a potential for litigation. So we like to refer to it as a bottom drawer exercise, in that you can do it now, you can put the documents away, hoping that you never need to rely on them, but ultimately they are there if a risk does arise. And when we have clients who are in business, there are always a number of different commercial risks, and that could be from customers or clients who are unhappy with the products they were provided with or with the services provided, particularly for people like us, lawyers and accountants. There's always a risk of negligence claims, which can, to an extent, be dealt with via insurance, but not always. Then you would have suppliers who would need to be paid, landlords if we've got business premises being rented. Of course, you would have financiers, banks, subcontractors. All of those different parties could pose a risk to those in business. And then even for people who are not in business, there's always the threat of a left field claim being made against you. In the event that that risk does materialize, there is a high possibility that you could end up in a commercial dispute. And so on this slide, I've set out what the general commercial dispute process is. You can see there that I've put process in inverted commas because every litigation, every court proceeding will vary. There may be additional steps. There may be less steps than what I've got on the slide. It will really depend on a case-to-case basis. And I've put some of those variations on the next slide. However, I will for now just go through the normal course that a commercial dispute would follow. So initially, in the top left-hand corner, you would have what will be the plaintiff setting out their claim or their demand to the defendant. So they may write to the defendant and say that they have been involved in negligence, or they may say that there has been a breach of contract, whatever the case may be. And they will set out what kind of relief they are seeking, whether that's monetary or perhaps they want something to stop. They want a Facebook post to be taken down, for example, whatever it may be. The defendant would then have an opportunity to respond to that person or that entity. And if they think that they are in the wrong, they may pay the money and settle it there and then. Otherwise, it may be a case of setting out why they don't think they're responsible, in which case things will generally ramp up from a litigation perspective. The plaintiff may often then send to the defendant a letter of demand saying that unless the amount is paid within a specified period, that they reserve the right to commence proceedings against the defendant without any further notice. If that letter of demand is not complied with, the defendant doesn't do what the plaintiff is asking for. If the plaintiff thinks that it is in their best interests, they may then engage lawyers and have a statement of claim prepared. And that statement of claim will set out the different facts and circumstances which gave rise to the damage or the loss. It will set out who exactly they're suing, what court they're suing in, and also what kind of damages they are seeking from the defendant. So if they decide to go down that road, that statement of claim would need to be filed with the court and also served on the defendant. From there, the defendant would generally have 28 days in which to put on their defence. So that would be where they respond to the statement of claim and say which paragraphs they agree with, which paragraphs they dispute, and essentially putting forward their side of the story. From there, we might have a disclosure process. So that would be in the court where you would have things like notices to produce, subpoenas, discovery issued. And the purpose of that is to make sure that all the relevant evidence in the proceedings is available to the parties and to the court. From there, each of the parties would have an opportunity to put on their evidence, setting out their side of the story and producing the documents which really support that position. So that would generally be in the form of an affidavit. If we're talking about a court proceeding, in a tribunal, it may be an affidavit or a written statement. You may also have some expert witnesses who weigh in on the expert view of what has happened in the proceedings. You may also have some third-party witnesses who have evidence relevant to the proceedings. Once all that evidence has been put into court, the parties may look to hold some alternative dispute resolution processes. So on a good day, the parties may take it upon themselves to hold an informal settlement conference, or they may even look to hold a private mediation. In some circumstances, the court will even order the parties to attend a court-ordered mediation where they think that there is some prospect of the parties settling the matter. If that is successful, that's fantastic. The parties can settle that way. Otherwise, the parties would then be looking to prepare the matter for trial. So a hearing date would be set down, and certainly by then you would have barristers, counsel briefed in the matter, and they would look to put together their opening submissions, put together their objections to the evidence in the proceedings, and preparing also the witnesses for their examination and cross-examination. From there, you would then, of course, have the hearing before the judge if you're in a court, or a magistrate, or even a member in a tribunal setting. And the length of that hearing will clearly depend on the complexity of the dispute. And once that's all been finalised, the judge or the member would then take some time to consider the evidence in the hearing and to form their decision. So that decision would ultimately set out whether the plaintiff is successful in the relief that they are seeking, whether the defendant is liable for what they've been accused of, and also it will say what the cost order in the matter is, who is responsible for paying the legal costs. Now, I don't have it on this slide. However, there is the potential for that decision then to be appealed. For example, if the plaintiff wasn't successful in their action, they could look to appeal that decision to a higher jurisdiction. Or on the flip side, if the defendant has been held liable and they think that there was an error made there, they also could appeal that decision. If there was no appeal and we're sticking with that original court decision, that would be where the plaintiff would then look to enforce that judgment against the defendant to recover the money that the court has deemed owing to them. So that's the general process that a commercial dispute will follow from start to finish. Like I mentioned, there's no one size fits all. There's no it's not going to follow the same process every single time. It will depend on a number of different factors, such as the nature of the claim or the dispute, and also the quantum of the claim in terms of how much the plaintiff is seeking from the defendant. Both of those factors will have an impact on which court or tribunal the dispute is actually brought in. So depending on how much the plaintiff is claiming and the type of dispute will determine whether it can be heard in the local court, the Supreme Court, the Administrative Appeals Tribunal, etc. The length of the process will also depend on how many parties are involved, how many plaintiffs, how many defendants are involved in the proceedings. And it will also depend on the relationship between the parties and whether they would be willing to negotiate some sort of settlement in the proceedings. So, for example, if we have family members or business partners who perhaps don't have such a pretty history between the parties, there may be a bit more tension there, and it may be a bit more difficult for them to come to a commercial resolution because there are those, I suppose, personal feelings and angst there. Another factor which would impact on the process is whether there are any interlocutory steps. And by that, I mean, for example, if one of the parties is seeking a freezing order or security for costs, so things additional to the normal litigation process, that would clearly add to the amount of time and complexity in the dispute. And finally, whether there is an appeal of the final decision and whether that appeal the parties proceed with. But clearly from the past two slides, you can see that there is quite a lot of work and quite a lot of time and cost involved in a general commercial dispute process. Even if the dispute may seem fairly simple, it may be surprising to you how long these disputes can actually go on and the type of costs that you may be looking at. So it's not uncommon at all for a dispute to go from start to finish 1.5 to 2 years, perhaps even longer. And depending on the type of jurisdiction that you are in, for example, in the Supreme Court, it wouldn't be surprising to see legal costs coming in at over $100,000, which is obviously a large amount of money and a large consideration for most clients. In that, you also need to weigh up the cost of barristers, the cost of filing fees, all those different things which would add to the final bill at the end of the day. So when we are dealing with a commercial dispute and we are acting for a defendant, there are some general rules which we normally try to stick by. And the first of those is that the earlier that you can settle a dispute outside court, the better. Sometimes, like I said, the parties won't be willing to come to the table and talk about settling the matter. But if it is a possibility, if you can sense a bit of uncertainty or doubt from the other party, it's always a great idea to be able to sit down with them, put forward a settlement offer, because that would really avoid the stress and uncertainty that comes with litigation, as well as the enormous legal costs that can come with seeing a matter through to the final hearing. Another important thing to remember when we're looking at how the asset protection strategies come into effect with a normal litigation process is that they will not necessarily prevent that judgment from being handed down. So when I say that, I mean that if the plaintiff is suing the defendant for breaching a contract, and on the basis of the evidence, it does look as though the defendant has breached the contract, then the asset protection strategy itself will not prevent the judge from granting the relief to the plaintiff. However, the real power in the asset protection strategies is that they will prevent that judgment from being enforced. So even if the plaintiff is successful in that action, The strength of the asset protection strategies is knowing that if the plaintiff went to enforce that judgment and try to recover that amount from the defendant, there is that debt owing to the bloodline trust, and ultimately the plaintiff won't be able to get their hands on that money. And so for that reason, that's why the best way to use them would be to use the strategies as a powerful bargaining tool. Because if the plaintiff is commercially minded and they know what's best for them financially, once they realize that they have no prospects of recovering the judgment, even if they are successful, that would be a very good reason for them to work out a financial settlement with the defendant, and that would be the best way moving forward. However, like I said, it's not always possible to settle. That would be our preferred approach. However, there are a few different approaches that can be taken depending on the particular circumstances. So the number one approach would be to try and reach a settlement with the other party to keep the costs low for both parties involved. However, sometimes you may need to put on a defence in the proceedings and see the hearing through to its conclusion. And that may be for a couple of reasons. I mentioned the clawback period before, and I'll come back to this. However, it may be necessary to get involved in those proceedings so that the asset protection work can get outside the clawback period, because we ultimately want that gift and that loan back, that transaction, to be protected and safe from clawback by a trustee in bankruptcy or a liquidator. On that point, you may want to defend the claim because you really don't want to go into bankruptcy, or you don't want your company placed into liquidation. That's quite a legitimate concern for most people, because there are complications that come with both of those processes. Alternatively, like I said, it may be quite a personal dispute, and the defendant simply may not want to give the plaintiff that satisfaction, and they may be trying to protect their reputation as well. So even though there may be a significant amount of legal fees involved, it may be in the best interest of some parties to defend that claim. The final approach which I've got there would be in situations where the defendant doesn't want to waste their time and money on going to court, and they're confident in their asset protection strategy. They're confident that it has been implemented correctly, and they're confident that they are outside that clawback period. In that situation, they may decide not to put on a defence at all. And in that situation, they would be focusing their efforts on the bankruptcy or insolvency process to make sure that the trust security can be enforced, and at the end of the day, there's nothing recoverable for the plaintiff. So quite a varied set of approaches there, which will depend on each client's circumstances, which I will go through now.
Kate, before you do,
Sure.
I just might jump in with a question, and it is, what about if someone dies within the period? How does it stand up then?
Well, we normally work it into the asset protection documents or a person's will that the debt, the secured debt, and all those mechanisms there carry on after a person passes away. So they would generally retain the protection of the asset protection strategies which we have implemented.
Thanks, that's all.
Okay. All right, so on this slide, I've put in there a few different considerations. These are more of the legal considerations in terms of how a client's defence would hold up in court and whether it is worth pursuing. So firstly, you would need to get some legal advice on whether the client does have a reasonable defence to the claim that has been put against them. Another thing to look at is, do they actually have much evidence available to them? They may have a good defence, but if they have no substantive evidence to back that up, it may be very difficult for a court to find in their favour. You may look to have other witnesses involved, but they may be unwilling or unable to give that evidence. So it would then be a matter of looking at their prospects in defending the claim, both looking at their legal grounds and also the evidence available to them. Another important point is whether the plaintiff has indicated a willingness to either mediate the dispute or to negotiate a settlement. If that has been offered up, then that is a great opportunity, which should, in most situations, be taken. Another consideration to take into account is what the likely cost orders may be in the court proceedings, whether there is a potential for an adverse cost order to be made against the defendant. That would be another thing which would need to be weighed up. On this slide, I've put more of the cost-benefit analysis considerations. So when deciding which approach to take, it would also be clever to look at the quantum of the claim and compare that to what's actually at risk. So it would be looking at the amount of the claim and then looking at what assets are actually held by the defendant. It may be the case the defendant doesn't have much to their name. They may have most of their assets held in the wife's name, for example, meaning that there would be a much reduced risk for them. And you would also be looking at what the likely legal costs would be to see the matter through to its conclusion. So clearly, if it's a small claim, you may be more willing to settle that and to walk away. Whereas if it's a larger matter, you would really need to be weighing up how much it's going to cost you to fight that matter compared to what you may actually lose if you don't win. And the final dot point on that slide is whether the asset protection work is safe from clawback. So when we're talking about bankruptcy or insolvency, there is the possibility there for the trustee in bankruptcy or the liquidator to look back on particular transactions, and if they think that they are in breach of the Corporations Act and all those different provisions, they may look to claw that money back and potentially have that available for creditors. So when we are talking about individuals who end up bankrupt, it is a 4-year clawback period for an undervalued transaction. It is 4 years when it can be proven that the individual was solvent when they made the gift. If that can't be proven, then the clawback period is actually extended to 5 years. However, if you have a look on this slide, on the right-hand side, the act of bankruptcy happening in May 2021, we would need to ensure that at least 4 years have passed from the date of the gift to make sure that that gift is safe from clawback. So in that situation, it may be a case of looking at when the work was implemented, and it would need to have some serious thought given to it if a claim did arise within that 4-year period. So occasionally clients implement the secure debt strategy and then they unfortunately have a claim made against them, perhaps within 1 or 2 years. If a judgment were to be made then and there and the client put into bankruptcy, that transaction could very potentially be clawed back. So what we would need to do in that situation would be to try and draw out the proceedings, try and draw out the actual act of bankruptcy to make sure that that 4-year period had elapsed, because we want to make sure that that gift is protected. However, with delaying that process, obviously involves additional cost and additional stress to the client. So that would again be weighing up what is the amount of the claim versus what will it cost me to protect it. There's a similar clawback period when we're talking about liquidation, and the 6-month period that I've got on this slide would be for unfair preference payments from a company to an individual, for example, but it's a similar concept. And then finally, I've got some more considerations on this slide in terms of bankruptcy and insolvency. So one of the approaches that I had put on the previous slide was not putting on a defense and just allowing the defendant to go bankrupt or the company go into liquidation. However, that's not always a practicable or an appetizing approach for clients. They may very well not want to go bankrupt because that would impact on their ability to run a company, for example, to be a director. It would impact their ability to obtain finance and a number of other things like that. Similarly, the company may still be trading, it may still be doing business, and so it would definitely not want to go into liquidation at that time. And finally, another consideration would be whether an individual, for example, has given a guarantee over company debts. That could potentially change the approach that is taken. So, as I've gone through those different approaches and the considerations, I've said that sometimes settlement isn't possible. Sometimes you need to put on that defense and go through the whole litigation process. And sometimes if you don't have a good defense or the evidence simply isn't there to support you, that decision may be handed down and you may be placed into bankruptcy or insolvency. With any litigation, it is uncertain. It could completely depend on the view that the judge takes on the day. So that is always a possibility when we're talking about a commercial dispute. However, bankruptcy and insolvency is another process in itself, and there are a number of risks and complications which can come with those processes. The main one is that the client's affairs are completely taken out of their hands. So the trustee in bankruptcy would be appointed, or the liquidator would be appointed for a company, and it would be their responsibility to take over control their assets and their debts, and the client would no longer have any say. The other complication with those processes is that under the legislation, the trustee in bankruptcy or the liquidator has such wide powers to request information and to make other requests of the individuals involved. Those requests can often be quite onerous. It can place quite a large burden on the client to put all that material together and to respond to those requests. And if you fail to do so within the given time frame, there could potentially be civil and or criminal penalties which could apply. So that can often be quite a risky and a stressful area for clients. Another thing when we're particularly looking at insolvency and a liquidator being appointed, we see it fairly often that the directors of that company can receive quite a nasty letter from the liquidator alleging that they have committed any number of breaches of the Corporations Act. So they might say that they knew the company was trading insolvent, they received an unfair preferential payment, etc. And they might demand that that individual or that director compensate the company for the loss which it has suffered. Sometimes those accusations are justified, other times they're not. But the thing is that the liquidator, if they do think there are potential grounds for suing the director, they can summon the director to attend a formal examination at the Supreme Court. And that can be quite an intimidating experience because you will have a well-trained barrister there asking you questions for sometimes days on end about your involvement in the company and the company's affairs going back for quite some years sometimes. And from there, if the liquidator isn't particularly happy with the evidence that you gave, they can then look to commence proceedings against you for those breaches. So it may be the case that if a liquidator is appointed, you have this additional headache and this additional set of proceedings which you then have to worry about. But sometimes bankruptcy and insolvency can't be avoided. In that situation, it would just be a matter of trying to manage that process as best as possible. And when the act of bankruptcy or insolvency occurred, that would be when the trust would look to enforce security. So the trust would then need to lodge its proof of debt with the trustee in bankruptcy or with the liquidator, and would need to set out the reasons why it is owed the money under the protection strategies. So that would be a matter of lodging the loan agreement and the registered security, so the mortgage or the security deed, and relying on those documents to support its claim over the individual or the company. I'll now take you through a brief case study based on a client of ours. So that client was based in WA, and unfortunately he suffered from a few major health issues, and that really impacted on his ability to carry on his business and to manage his financial affairs. It came to a point where he started defaulting on his bank loan, and eventually the bank looked to, they petitioned to declare him bankrupt, and they were successful in doing that. So in terms of time frame, he was declared a bankrupt in 2019. However, fortunately for the client, we had in 2013 done some work with him to implement our secured debt strategy. And the assets at risk were 4 properties of his, which we had protected under the secured debt strategy. So like I mentioned on the previous slide, we acted for the client and we were responsible for liaising with the trustee in bankruptcy, and we were able to identify the security over the properties and the debt owed to the trust, and it was a positive outcome for the client at the end of the day. I've put in a couple of quotes here from the trustee's report to creditors, and what was ultimately decided was that there was no equity in the properties because of the debt which we had established in favour of the trust, and therefore the trustee decided not to commence any action to realise the properties at this stage. And also there I've put that a dividend to ordinary unsecured creditors was not likely to be paid. So the takeaway from that is that if your client does end up in bankruptcy and you were lucky enough to have some asset protection work in place, you can rest assured and rely on that process to know that the likely outcome is that the trustee in bankruptcy won't look to sell your house. They won't look to realise your assets because they know that it's not in the best interests of creditors. So I'll just summarise my presentation today. So hopefully what you've learned from this is that asset protection strategies can be very effective at defending a claim and making sure that particular assets are not lost to creditors. It is important to make sure that they are implemented correctly and that they are implemented early enough, particularly to get outside that clawback period. I've been through the different approaches that can be taken, whether that be defending the claim or not putting on a defence and focusing on bankruptcy or insolvency, or ideally looking to settle the matter outside of court. But it's a big strategic decision to be made, which will depend on a lot of different factors. And that's why we would hope to get involved and get barristers involved to work out exactly the best approach to take. So I think if there are any more questions, Adrian, that's probably at the end of my webinar.
Thanks, Kate. We'll just leave it open for questions for people to fire any in. As I mentioned, if you can fire them in via the chat function so we can see them. Grant, I noticed that you've got your hand raised. I'm not sure whether that was a mistake or not, but if you do have a question, if you just want to use the chat function to send that through, and we'll keep it open. While we're wrapping up, should mention that you will receive after today an email containing a feedback survey. We'd really appreciate it if you took the time to answer that. It's only a couple of questions, but we do take all the feedback on board, in particular in relation to future webinar topics that you'd like presented. On that, some, I guess, exciting news in that in consideration of the lockdown that a lot of us find us under at the moment, we will be moving to a fortnightly webinar rather than a monthly webinar. So our next webinar will be in 2 weeks from today. And the topic for that one is going to be having a look at the case involving Eichmann, which is a case relating to CGT small business concessions and in particular active asset. After that, 2 weeks after that, we're going to have a presentation on trustee resolutions. So having a look at the traps to make them effective from both a tax perspective and then also trust law perspective, having a look at some recent cases in relation to that. Those 2 webinars are already loaded for registration on our website, so you can register for them now if you wish to do so, and there will be a link to that in the feedback email, which you'll be receiving as well. If you haven't had a chance to download the slides from today's session, there'll also be a link to those in the feedback email, and as mentioned earlier, the recording for this webinar will be available on our website later on today if you came in partway through or had to leave. There is a question here, so I'm just going to read it so I can ask Kate. Kate, are there any underlying principles that the court usually relies on to determine who is liable for court costs?
Okay. So you would have, there are general cost principles, and then that can be varied to be an adverse cost order in a few different situations. One of those is where there is a cold bank offer. I'll explain what that is. It's basically where, for example, the defendant offers to settle the matter for $50,000. If at the end of the day, the court awards the plaintiff less than that amount, the court will look and say that the plaintiff has essentially wasted the court's time because they could have settled the dispute for a higher amount. And in that situation, the court may be able to award adverse costs in favour of the defendant. Other situations may be where there's been some sort of poor conduct by one of the parties in the proceedings. There may be an adverse costs awarded then.
Thanks, Kate. I mean, the general principle, as they say, costs follow the event. So in short, if you lose, generally, you have to pay costs, recognising that there are some jurisdictions that don't generally have costs, such as the AAT. I'm going to close it off there. I'd like to thank Kate for her presentation today, and thank you for attending. We hope you got something out of it. And as I said, keep an eye out for that feedback email, which will include the links to the next webinars, which will be running every 2 weeks from now. Okay, thanks everybody. Thanks, Kate.